Hey there, guys. No, I've not done a video in a little while, but I thought now that you've done your contract coursework and you've got EU law coming up in the next few weeks, I'd do a video about the EU coursework. So we're going to be looking at Articles 258, 259, and 260, in general, the enforcement procedures of EU law. At the start of the lecture, I'm going to sort of talk a little bit about what the procedure is under Article 258, 259 and 260. But what I really want to focus on in the second half is how you're going to pick up the marks in the coursework. In other words, how you're going to get that critical analysis in. So we're going to do that by looking at the advantages and disadvantages of the procedure so that you can get top marks in the coursework. All right, let's begin. So I think the first thing to note about this is that I've called this the EU law enforcement procedure, and a lot of books call it the enforcement procedure as well. But the EU itself calls it an infringement procedure instead. So this is quite important when you're looking for things like journal articles and other stuff to add to your coursework, because if you're searching for enforcement procedure on Westlaw or Lexis Library, or even on the Europa website, you may find it more useful to search for infringement procedure instead. So I think the first thing we've got to sort of think about in relation to Articles 258, 259 and 260 is what is the purpose of them? Why do they have them? And I think in relation to sort of any other area of law, it has to be enforceable. So you think of a contract, in order for businesses to operate, the contracts have to be enforceable. Similarly, for criminal law, the criminal law and statutes have to be enforceable, else society would simply disintegrate. And in a similar way, if we didn't have Articles 258, 259 and 260, then potentially the EU itself would disintegrate. So what I've referred to here is Article 4.3 of the Treaty on European Union. And you can read there, it says the member state shall take any appropriate measure, general or particular, to ensure fulfilment of the obligations arising out of the treaties or resulting from the acts of the institutions of the Union. In other words, if the EU tells a member state to do something, then they should do it. And 258, 259 and 260 are there in case member states don't do what the EU asks. So when you're assessing the effectiveness of Article 258, 259 and 260, you can start by saying, well, this is the purpose of the articles. And then at the end of your essay, you can sort of come to a conclusion based on, well, does it serve that purpose? Does it make sure that EU member states follow EU law? If it does, then they obviously work. If it means that member states don't follow EU law, then we can say that it doesn't work. So what's the difference between Article 258, Article 259 and 260? Well, you can normally do this by looking at the case names. So Article 258 is where the Commission brings an enforcement action against a member state. So the cases will always look as Commission versus member state. So it will be something like Commission versus Poland or Commission versus France. Article 259 is slightly different, and we'll look at that in due course, but it's basically where a member state instead of the Commission brings the enforcement action. So these will often look at like Spain versus the UK or France versus Germany, something like that. And finally, Article 260 is more of like an addenda to these articles. It's the fine system that's in place, and it basically gives the whole procedure teeth. So rather than the EU simply telling the member states what to do, they can say, if you don't do what we say, then we're going to fine you. And we'll look at how heavy the fines can be later on. So first, let's just have a look at the procedure and sort of try and understand how they actually work before assessing how effective they are. So as I said, Article 258 is where the Commission brings an enforcement action against the member state. And I've drawn a little diagram here to try and show you how it works. So we start at the top with an informal inquiry. This is basically where the Commission goes to the member state and says, look, we think that you've breached EU law. Before we take this any further, can we sort this out and reach an amicable conclusion rather than having to go to court over this issue? And one of the advantages that we'll talk about later is that a lot of problems in terms of the enforcement of EU law are solved at this stage. Approximately 95% of cases are actually resolved at the informal inquiry stage. And this saves the Commission a lot of money, saves the EU a lot of money, and I guess in turn saves the taxpayer a lot of money as well. So it's quite an effective system in the sense that it doesn't waste time by going straight to court and involving lawyers and a whole lengthy process. A lot of it is solved in quite a friendly manner. However, sometimes this isn't possible, so we move on to the next stage, which is where the Commission sets out a formal letter to the Member State and basically says, this is how we think you are breaching EU law. This is the particular provision that you've not implemented. Can you try and solve it, please? And so at this point, the diagram splits into two. So either the member state responds and says, we don't think we've breached EU law, or we know we've breached EU law, but this is the reason why. Or alternatively, if the member state doesn't respond within 2 months, then they move on to the next stage. And as you can see, this next stage is the reasoned opinion, and this sets out the legal and factual basis for the breach in EU law. In other words, the Commission takes what was in the formal letter, what it thinks is the breach. It takes into account the member state's response to that breach and sort of summarises it all into one helpful document. Tries to put it all together and come to a conclusion about sort of whether it feels there's been a breach, and it sets out exactly what that breach is. So I've put all of these together, and these are called the administrative stage, but we can actually move on, if we like, onto the next slide, and we'll move on to what's called the judicial stage. And this is obviously where the case goes to court. So it's heard before the Court of Justice of the European Union, and they basically decide the case. So on the one hand, we have the Commission prosecuting and the member states defending their actions. I think it's important to point out that at the judicial stage, it's up to the Commission to prove the breach. So in the same way in criminal law, you're innocent until proven guilty. Similarly, the member states are innocent until they're proven guilty of a breach of EU law by the Commission. So we could say that that's possibly an advantage, but on the other hand, we'll see later on that the defences that the member states put up tend not to really work, and they're generally quite ineffective. So there is something of a bias towards the Commission at this stage that we can talk about. Moving on, at the end of Article 258, the court will issue a declaratory judgment basically saying, yes, there has been a breach of EU law and this particular member state is in breach. But like I said at the start, this would be completely ineffective without any sort of force behind it. And that's where Article 260 comes in, which is the fine procedure. In other words, fining a member state for their breach. And we'll look at that later on. So Article 259 we can look at, it's basically very similar to Article 258. One of the things to say about Article 259 just before we start is that it's very rarely used. There have only ever been in the history of the EU 3 Article 259 cases. And the reason for this is because of the potential diplomatic fallout between countries when an Article 259 case is brought. In other words, if you think that if the UK brought a case against Germany, for example, it would make things very awkward between David Cameron and Angela Merkel. So as a rule, countries tend not to prosecute other countries. One of the other reasons that Article 259 is not used very often is because the Commission has a tendency to take over Article 259 cases. So a country may start the process, but by the end it might be the Commission that takes over and eventually prosecutes the member state under Article 258 instead. This possibly most famously happened when the mad cow disease happened in the UK during the late 1990s, and Britain tried to prosecute France because France refused to import any British beef. So that was going to be an Article 259 case because it would be UK versus France, but instead the Commission decided to take over the case instead, and so it became Commission versus France instead. So we can see the Article 259 procedure. It begins with the complaint by the member state, um, and then there is the reply from the other member state. So it's quite similar in the sense that in Article 258 it would be the Commission who brings the original complaint. Instead, we have a member state here. So one member state complains about another one, the defending member state gets a reply, and then the Commission does come in at this stage potentially and can either issue a reasoned opinion, or if it doesn't issue a reasoned opinion, then the case can continue anyway. So then it moves on to the judicial stage, as we saw before. The case would go before the court. Lawyers from both countries would argue their case, and they would eventually come to a decision. If they find that the member state has been in breach of EU law, then again we can move on to Article 260 at that stage, and the member state that has breached EU law can then be fined. So let's have a look at this fine procedure then. It's very similar to the Article 258 procedure again. The only thing that we miss out in comparison with Article 258 is the reasoned opinion. So there's still a number of stages to go through. We have an informal inquiry about why has the member state still not rectified the breach of EU law. Then the Commission sends the letter. We have the potential for a response from the member state within 2 months, and then again the case will go to the Court of Justice of the European Union. And essentially we're arguing at this stage it's a pretty open and cut case, because we definitely know that the member state has breached EU law because the court has already decided that under Article 258. The only real question for the court at this stage is how much should the country be fined? And we can have a look at how much the country can be fined here. So the court can either issue, on the left hand side you can see a penalty payment, which will be a regular fine, or it can just impose a lump sum. And we can see that we take into account different things here. So we have a basic rate for either. So the basic rate, if we focus on the penalty payment first, is €670. This is then multiplied by the seriousness of the infringement. So a not very serious infringement would only be times by 1. If it was a very serious infringement, it would be times by 20. Then take into account the duration of the breach. So that's measured between 1, so not very long for 1. And if it's gone on for a long time, it can be multiplied by 3. And then finally, this looks a little bit complicated, but I promise it's not. It's then multiplied by an n factor, which can be anywhere between 0.35 and 21.21. And the n factor is basically based on a country's GDP, or gross domestic product. To put it very simply, if it's a rich country like Germany, it gets multiplied by a lot. And if it's a very small country like Malta, for example, it gets multiplied by a very small amount. So the two countries that I've given there are examples of the extreme. So the smallest n factor is Malta with 0.35. The biggest is Germany with an n factor of 21.21. I think the UK's n factor is around 19, and I think France's is very similar. So it's a similar thing for the lump sum payment as well. The only difference really is that instead of taking into account the duration, we instead look at how many days the breach has gone on for, and that's what we multiply it by. Right, so hopefully you're familiar with the procedure now. If not, those charts should make it fairly simple. But I think what I really want to focus on are what are the advantages and disadvantages of this enforcement procedure. As I say, if you know the procedure itself, you're going to get OK marks in the coursework, but realistically where your critical analysis marks are going to come in, which will take you into a 2-1 and a first category, are going to be looking at sort of, does it work? Does it serve the purpose like we said at the start? What are the advantages? What are the disadvantages? So advantages first, most cases are resolved without going to court. So as I said, about 95% of cases are solved at that informal inquiry stage, and this obviously saves the Commission a lot of money and a lot of time and hassle as well. So that's a really good thing. one of the things you might want to look at in your coursework is what are the alternatives to Article 258 and 259. And the EU has come up with a lot of programs whereby people can make complaints themselves as an individual, or countries can sort of negotiate with the EU how they're going to implement EU law. In the end, a lot of the cases come down to communication between the EU and the member state, and programs like EU Pilot and Solve It have gone a long way to helping that process. Secondly, it serves its purpose. So we talked at the start about Article 4.3 of the Treaty on European Union and the purpose there. I think we can safely say that the Article 258 procedure does work, in the sense that it ends up with the court making a judgment about a breach of EU law. And furthermore, Article 260, the fine system, provides a deterrent for making states not breach EU law. And that links into the fines acting as a deterrent. I think also good essays will look at other articles as well. So we've got Articles 278 and 279. These are basically interim procedures. So if a case can take a long time to go to court, Articles 278 and 279 act as suspending the law while the case is going through. So you can look up those in your own time, basically going on the TFEU website and having a look at that. So disadvantages, as I mentioned during the lecture, the defences rarely succeed. So realistically, the only defence that's really going to work for a country is that there simply hasn't been a breach of EU law. Other things, such as in re-tachographs, the case that I've put there, which was Commission versus UK from 1979. This was where there had been a number of strikes and political action, and even when this had occurred and it was beyond the government's control, they were still prosecuted under the enforcement procedure. Another disadvantage is that you as an individual couldn't bring a case under Article 258, or 259. These are focused on the Commission bringing a case in Article 258 or the member state bringing a case in Article 259. So individuals are excluded from the process, but I've put there that individuals can also have a look at direct effects. So this comes back to the idea that I mentioned earlier about seeing EU law as a whole. So we can look at Articles 278 and 279 in terms of the interim measures, but we can also look at direct effect as well. So individuals do sort of have remedies if EU law has been breached, and they can do that in the national courts. And the most famous example of that was Van Gendenloos from 1963. Another disadvantage is that the Commission has limited resources. So if lots of countries are breaching EU law and there's been some big breaches, then the Commission is obviously going to focus on them. And this means that some minor breaches can often go unnoticed. Finally, the Commission also has a lot of discretion when it comes to proceeding to the judicial stage. So we talked about the administrative stage under Article 258, and then on the next slide we had the judicial stage. After the reasoned opinion, the Commission can decide, actually, we're not going to take this to court. We don't have enough resources. We don't think that the infringement is serious enough, and they can decide not to do that. Also, they can decide not to investigate a problem in the first place. And this is what happened in a case called Starfruit versus Commission, which you can look at. And they said that the Commission has no obligation to investigate. We can also look at these cases of Commission versus France, where the Commission left it a long time before prosecuting the case. And whilst in Commission in France they said that this was okay to leave it for a long time, in the later case of Commission versus Netherlands in 1991, they said that if the Commission leaves it too long, then it could be prejudicial against the member state to prosecute at that stage. So the Commission can leave it too long and be locked out of the process effectively. So one of the problems that we often have in terms of researching this area is looking at resources. That tends to not really be a very popular area for either case law, I mean, there's a fair few cases out there, and if you look up in your textbook in the cases list, you can see commission versus, there'll be a lot of cases there, but not all of them are useful or particularly illustrative of some of the points that I've mentioned. So you'll have to look up journal articles and other things either online using Google Scholar or using Westlaw or Lexis Library. So I did a quick search on Google Scholar and I found these three things here. In particular, that first one looks pretty good. It's quite an up-to-date book, The Enforcement of EU Law from 2012. So it looks at it in the light of the Lisbon Treaty. Similarly, that second article looks at Article 260. So how effective is that? Does the fine system really work? Is it effective as acting as a deterrent? And then that final article that I've put there mentions some of the things that I mentioned in the lecture, like Solve It and EU Pilot. In other words, can we avoid using the judicial process under Articles 258, 259, 260, and instead try and work more on communication so that we can solve even more than 95% of cases in that informal inquiry stage. So that lecture lasted a little bit longer than I thought it would, but hopefully you now understand a little bit more about the procedures under Articles 258, 259 and 260, and can also begin to think critically about what are the advantages and disadvantages of the process. I think that ultimately it comes down to this mechanism is designed to make sure that EU countries abide by European Union law. And you've got to come to a decision about how effective are the articles in making sure that that happens. I remember that when I was a student, I did an essay on a similar topic, and I mainly focused on the Solve It and the EU pilot scheme in terms of trying to solve the issues before they even enter into the Articles 258 process. So even though there's maybe not a huge amount of case law on this issue or a great number of journal articles, there is still stuff out there. And also you can look on the Europa website for statistics and other things that the EU itself has produced, and try and find some interesting points to include in your essays. I think there's a great opportunity here to include some stuff that other people might not have thought about or even really looked into. So best of luck with it. Leave a like and subscribe to this channel for more videos. And as ever, leave a comment in the box below with a question or a query, something else you want to discuss, and I'll make sure to get back to you as soon as I can. Thanks very much for watching, and bye.